Good morning, everybody. We have, I think, maybe give a few more minutes for people to join. All right, I'm going to get us started. If a couple of people join late, it's okay. It's just me waffling. So good morning and welcome to Azuro's very first webinar. For those of you who don't know me, my name is Johan Ungerer. I am the founder and CEO of Azuro Solutions. Today we're going to talk a little bit about the Protection of Private Information Act, or POPIA for short. Considering that the provisions of the Act become enforceable from tomorrow, we found that there's still many misconceptions about the ambit of the law, how it will impact life and business in South Africa. And so Simone Daisel will endeavour to demystify this Act for us a bit today and try and condense the Act to clarify the most important questions, what it is about, why is it needed, what must I do to be compliant, and very importantly, what's the worst thing that could happen if I don't do anything about it. Simone joined Azuro last year in July, and she heads up our process and collaboration team. She also consults to a number of our clients on compliance and governance issues, especially around ensuring good governance and practices are implemented over the information and data estates of our customers to ensure that you remain compliant with the applicable legislation. Prior to joining Azuro, Simone worked her way up as an intern through call center and desktop support to operations management, architecture, strategic consulting positions, and there she gained valuable experience in the real-life impact of policy, process, and procedure decisions. She has a focus on functional IT service management and enjoys all things compliance. She often quips that she enjoys making order out of chaos. She has a strong grounding in the ITIL framework and is also familiar with other ITSM frameworks such as COBIT and ISO. Building on this experience, she was able to build a deep understanding of POPIA to consult on its impact and practical implementation for our clients. When she's bored, which isn't very often, she also looks after our WordPress environments and produces our marketing graphics. Also joining us this morning is Angus Prince. Angus is the Managing Director of Azuro Coastal and has been part of the Azuro family since July of 2019. Angus's career spans more than 20 years, the majority of which has been spent in operations management, consulting and outsourcing. Prior to starting the Coastal division, Angus headed up the Dynamics area for a major corporate in the Western Cape. Just a quick note about Azuro. We're a Microsoft Gold partner, and our focus is on delivering value to our customers by helping them navigate the complexities of modern IT solutions, taking the guesswork out of choosing the right acronym to solve a particular business challenge. We take a forward-looking approach to these solutions to ensure they serve the objectives of our customers in the long term. We have customers and offices in South Africa, the US and the UK, and hoping to get some more footprint in Africa and other places. Lastly, it's important to note that we are not offering a legal opinion today. It is a practical implementation of the Act and how it will likely affect your company or any other juristic entity that deals with personal information. And that's my story. I hope you enjoy the content. Simone, over to you. And I misclicked. Hang on one second.
Thank you, Johan. Let me just get my timer started so I make sure that I don't keep you here longer than you'd like to be. Okay, guys, so a few things before we kick off. The Act in itself is a lot of information. We don't have an entire day or an entire week to chat about it. Some of these slides are going to seem content heavy, and it's because they have a lot of content in them. Others won't be so heavy. Towards the end of the presentation, we're going to go through things a lot quicker. But yes, all in all, I hope that this perhaps simplifies the Act a bit, makes your understanding of it a bit easier, and I'm hoping we can answer some of the the simple questions that we've got. So just running through the agenda, what we're going to be touching today, what is POPIA, what is your right to privacy? We're going to be talking about data subjects, responsible parties and operators. Everyone talks about processing information, but actually not many people understand what processing actually means. So we're going to have a quick look at that. Also, what is personal information? What is special personal information? What the differentiators are there? There are certain ways that you need to deal with both types of information sets, certain rules that apply. We'll talk about what the information officer is, and we'll touch on the expected responsibilities for that role. And we'll also look at some core action items. If you have to whittle down all of the responsibilities and all of the key things that need to be in place before tomorrow, which, don't worry, 99% of businesses will not have in place. We're just going to look at sort of a whittled down list of the core things that need to happen. We'll be looking at building a data map. It's super important. It's one of the most important actions that the information officer has to look at. We'll briefly talk about privacy impact assessments, a vendor risk assessment, and the importance of a software audit, comprehensive software audit. We'll speak about core information security controls, direct marketing do's and don'ts. That's very quick. Some brief differences between GDPR and POPIA. We'll have a quick talk about transport and information flows, a quick chat about what needs to happen on your website, the updates to your cookie policy, the updates to your privacy policy, and then, of course, we will speak about the cost of non-compliance. As Johan mentioned, the question of so what? And that always makes me think of, there's a series called Chernobyl, and one of the chief scientists at the end speaks about what is the cost of lies. So, is it willfully being non-compliant, or is it being non-compliant by way of a misunderstanding, misinterpretation, or a mistake? We'll get to it. Key concepts, we have to understand these three concepts before we delve into the content, and it will become clear as we move through the content why that is. Data subjects. Data subjects are, in simplified terms, people, staff, customers, vendors, or businesses. Juristic entities, just for simple terms, is a business. A natural person, obviously, person walking about. Those are the two data subjects that you've got. Responsible parties are businesses that ingest information. It could be a life insurance broker, it could be a medical aid. It is the business that is the first sort of point of contact between the data subject and the business. And then operator is an organization that receives that data from the responsible party to perform a function, right? So to process that data in some way. And processing could be just storing, it could be reworking it to gain some type of business intelligence from it. It could be the medical aid passing on information to investors so that they can make something, out of what needs to happen with contributions. So those are the three important different roles to understand. Data subjects, people whose information is being captured, businesses whose information is being captured, responsible party being the one that ingests the data, and operator being a party that actually does stuff with data and then feeds it back to the business so that they can do something with it. Important questions. Where is your operator based? An operator could be something like MailChimp, for example, where you pass on information to MailChimp when you use it so that it can send out emails for you, which is a service that it renders for you. Where is that operator based? Is it based in a place where there is a data protection policy in place that is equivalent to POPIA? These are important questions to ask. What type of information are they receiving? Personal information or special personal information? Different rules apply. So data subject, responsible party, operator. Do I have to comply? Very simple. Is your company domiciled in South Africa? And do you process personal information in South Africa? Those are the two core qualifiers. Not much else to say about that. That's an easy question for you to answer. And then just looking at the types of processing that are exempted, because there are certain activities that are exempted. If you are processing information which is purely personal for a household activity, you're exempted. By or on behalf of a public body where it involves national security or where its purpose is to prevent or detect unlawful activities. So, just to quickly understand what that means, I mean, if you have to put someone under surveillance, you're not going to obviously inform them that you are going to be gathering their information before you start that surveillance. Information processing by a cabinet and its committees or the executive council of a province related to a court's judicial functions and which is solely for the purpose of journalistic, literary, or artistic expression. That is when you do not have to comply. And complying means, in brief, having to inform a data subject that you are gathering and using their information before you actually get to that point. So these activities over here are exempted from actually going through that process. Right, so what is processing? It includes, but is not limited to, storing information, printing, emailing, filing, updating, deleting, displaying, or faxing. I don't know who still faxes, but faxing is still on there. Storing data is processing data. Dropbox can be the operator. Where is Dropbox storing the data? Which data law applies? Important questions to ask. If you possess the data, it would have to have gone through some form of processing activity to get you to the point of having that data. If we speak about filing, are you using SharePoint? Where is your Microsoft 365 tenant based? Is it in South Africa? Is it in Ireland? Is it in another country? Which data law applies? These are important questions to ask when you look at the processing activity that you are executing and where that is actually being executed. Quick discussion on what personal information is, perhaps not so quick. Personal information is info relating to an identifiable living natural person, or where it is applicable, an identifiable existing juristic person, meaning a business. Special personal information is about religious or philosophical beliefs, race or ethnic origin, trade union membership, political persuasion, health or sex life, sexual orientation, or biometric information. In the GDPR, they actually refer to genetic information. South Africa doesn't refer to genetic, we refer to biometric. And then, of course, included under special personal information as well is any information relating to the alleged commission of any offense or any proceedings in respect of any offense allegedly committed and the outcome of such proceedings. Right. So Section 26 of the POPIA Act creates a special category for this special personal information that we just covered. And failure to obtain consent to processing this information specifically is strictly prohibited unless it's necessary by law, done for historical, statistical research purposes, or the information has been deliberately made public by the subject. That's the SPI, the special personal information. There are limited exceptions to the prohibition against the processing of SPI. Details of such exceptions are set out in the Act. Special rules apply to the processing of personal information or special personal information of children. That's set out in Section 35 of the Act. The information regulator has the power to grant exemptions to allow people to process personal information without complying with the Act if the public interest outweighs the subject's rights of privacy or where there is a clear benefit to the subject. You have to understand, guys, that even though the right to privacy is protected under the Constitution, or is a constitutional right under Section 14, the right to privacy is not absolute, and there's always a test of checks and balances, you know, the needs of the many versus the needs of the one, if I can use a Star Trek reference. Right, do I have to apply for prior authorization? The responsible party that intends to transfer for any purpose, such as storage or subsequent updating or modification, the special personal information or personal information of children to third party outside of the borders of the Republic must assess if the third party in the foreign country is subject to the law, binding corporate rules, or binding agreement which provide an adequate level of protection that effectively upholds the principles for reasonable processing of the information that are substantially similar to the 8 conditions for lawful processing covered under POPIA. Failure to obtain the consent, as we mentioned, for processing SPI, prohibited unless you cover the same distinctions we just mentioned. Prior authorization activities will typically include, if you run credit checks, you'd have to apply for prior authorization. In most cases, we actually run credit checks or criminal record checks, or work with the special information of children. Right, so the 8 conditions for lawful processing. This slide is a little content heavy, so it's got a lot of talking behind it, but it would have been a nightmare for you to read all of it. So just buckle in. The first one being accountability. Brief introduction to the 8 principles though. Being fully compliant with the Protection of Personal Information Act, there are 8 principles defined within the Act which must be addressed to be compliant. These are well-accepted attributes which are adopted throughout South Africa as the guidelines for a successful POPIA implementation. So principle 1, accountability. The organization must appoint a party, an information officer, who will be responsible for ensuring that the information protection principles within POPIA and the controls that are in place to enforce them are complied with. So it's really straightforward. Second principle, processing limitation. That deals with the lawfulness of processing, minimality of information collected, consent, justification, and objection, and the collection of personal information directly from the data subject. Also not very complicated. Purpose specification. The third principle provides that personal information must be collected for a specific purpose, and the data subject from whom the personal information is collected must be made aware of the purpose for which the personal information was collected. That's really important. Then the further processing limitation. If a responsible party further processes personal information, such processing must be compatible with the purpose for which the information was collected originally. So if you collected, or if you told the data subject that you collected it for one specific application or use case, you are not allowed to just unilaterally go and use the same information in another use case. Principle 5, information quality. The fifth principle provides that the responsible party must take reasonable steps to ensure that the personal information that has been collected is complete, accurate, not misleading, and up to date. In so doing, the responsible party must take into consideration the purpose for which the personal information was collected. Also fairly straightforward. Openness, very important point. It's the 6th principle, and it provides that the responsible party must be open about the collection of personal information by notifying the regulator if it's going to process personal information, and if personal information is going to be collected, the responsible party must take reasonable practical steps to ensure that the data subject has been made aware that his or her personal information is going to be collected. The responsible party should, for example, take reasonable steps to make sure the data subject is aware of its name, address, and the purpose for which the personal information is being collected. So that's really just a lot to say. The data subject needs to know what you are taking, why you are taking, and who it is that is taking the information. Then on to security safeguards. The 7th principle provides that the responsible party must ensure that the integrity of the personal information in its control is secured through technical and organizational measures. And this is where I just have to point out, guys, you'll see a lot of products pop up saying, if you buy this technology solution, it will make you compliant. There's no single piece of technology that can make you compliant. And you will always have to have organizational measures in place as well. And this is not something that you can template. If it was that simple, you could have purchased a compliant sort of kit in a box, right? It's not possible. You literally have to change the way you do business in many cases. And that's not something that a template can provide. That's something that you have to sit and sort of grind through as a business. Then the last principle, data subject participation. The 8th principle provides that data subjects have the right to request that a responsible party confirm free of charge whether it holds personal information about the data subject, and he or she may also request a description of such information, and then a slew of other rights as well, which we will get to in subsequent slides. Right, so let's move on. What is an information officer? Right. This top part comes directly out of the Act, guys. Not everyone always believes when we say this, but any person authorized as an information officer should be at an executive level or equivalent position. This means that only an employee of a private body at a level of management and above should be considered for authorization as an information officer of that body. POPIA requires every responsible party, in effect, public or private body, that determines the purpose of and means for the processing of personal information, to appoint and register an information officer with the information regulator. Information officers are, by virtue of their positions, appointed automatically in terms of the Promotion of Access to Information Act, or POPIA. The information officers, for purposes of POPIA, are the same information officers as referred to in POPIA. And in this regard, the information officer in relation to a public body means the information officer is contemplated as in Section 1 of POPIA, and in relation to a private body means the head of the private body as contemplated under Section 1 of POPIA. The head in the case of a juristic person means the chief executive officer or equivalent officer, any person duly authorized by that officer, or the person who is acting as such, or any person duly authorized by such acting person. So that just means under POPIA, the head of the organization is defaulted as the information officer, and POPIA applies the same thinking, okay? Accordingly, in respect of private bodies, the chief executive officer or equivalent officer is by default the information officer. This does not mean that you don't have to still register that officer, by the way. The chief executive officer or equivalent officer may, however, authorize any person to act as the information officer. Such authorization is required to be in writing, using a template that's substantially similar to the authorization template annexed to the guidance note that recently came out. There is an application form or a designation form in a pack on the information regulator's website that you can use to formally go ahead and designate that or delegate that responsibility. Despite the authorization to another person, the default information officer, meaning the head of the organization, retains the accountability and responsibility for any power or function authorized to the information officer. In terms of the guidance note, any person authorized as the information officer should be at an executive level or equivalent position. Further, to ensure accessibility of a private body, the information officer of a multinational entity, very important, based outside of South Africa, should authorize a person within South Africa as an information officer, and each subsidiary of a group of companies should appoint and register its information officer with the information regulator. Now, this has flagged some issues because in some cases, a holding company has a slew of subsidiaries and you're talking about maybe 5 people involved in that concern. and there literally aren't enough different people to register as different information officers for the subsidiaries. This issue has come up. The information regulator has acknowledged this issue. Currently, when you register an information officer on the portal, it will not allow you to use the same ID number to register as an info officer in different places. So at the moment, you have to manually submit applications where you need the same person to be the information officer in several entities. And they are busy approving that on a case-by-case basis. But, you know, when they set out to develop this act, they couldn't possibly foresee all the different scenarios that could possibly pop up. So it's quite normal for things like this to happen. Right, so who is the Deputy Information Officer? When an organization seeks to designate one or more Deputy Information Officers, having regard to its size, structure, or complexity, the guidance note provides the following assistance to organizations to identify the appropriate individuals for this role. Any Deputy Information Officer should report to the highest management office within the organization. This means that only an employee at a level of management and above should ideally be considered for designation as Deputy Information Officer. The Deputy Information Officer should be accessible, have reasonable understanding of the organization's operations and processes, and should have a good understanding of POPIA and POPIA in order to perform his or her duties. The Deputy Information Officer should be provided with sufficient time and adequate resources to devote to matters concerning POPIA and POPIA, and to ensure a level of accountability. Organizations may want to consider including the Deputy Information Officer's duties and responsibilities as part of his or her job description. And despite the designation of delegation to Deputy Information Officer, an information officer retains the accountability and responsibility for the duties and responsibilities in terms of POPIA and POPIA. So that's a lot, but actually fairly straightforward. So these are really the whittled down core duties of information officers. I'll quickly run through a more sort of detailed description, and then we'll just quickly look at these items as they appear on screen. These are good items for you to capture as a quick project plan, by the way. So the duties of the information officer, a compliance framework needs to be developed, implemented, monitored, and maintained. A personal information impact assessment has to be done to ensure that adequate measures and standards exist in order to comply with the conditions for the lawful processing, which we looked at earlier, the 8 conditions. Internal measures are developed together with adequate systems to process requests for information. So that's under POPIA, or those are for data subject access requests, which we'll get to soon. And then internal awareness sessions have to be conducted regarding the provisions of POPIA, the regulations, codes of conduct, where they apply to your industry, or any other information obtained from the information regulator. Okay, so let's quickly look at these action items. Internal privacy impact assessment. That's about just tracking how data comes into your organization, the different touch points it has with different people, departments in the organization, if there are any sensitive handover steps where information is transferred between departments or parties in a way that the information could be breached. Vendor risk assessment is to check it once again, pretty much the same. Is there ever a stage where you have to hand over information to your supplier or to a vendor where that exchange is actually not safe? Are they telling you to upload a list of payroll data with WeShare, for example, where you have no idea where that information is actually going? That's what the risk assessment is about. Privacy policies need to grow exponentially in the detail that they provide. You need to have a data subject access request procedure, which we'll get to in a bit. You have to map all of your data collection sources. It's so absolutely important, vitally important. You have to create an inventory of all of your applications internally and in cloud. You have to ensure appropriate security safeguards with governance and policy. With your website, you have to update your cookie policy, your privacy policy, and display acceptance banners and notification banners. You have to get your suppliers to acknowledge that they will process your information in compliance with the POPIA requirements. You have to let your customers know that you will, going forward, comply with the POPIA requirements. You have to train your employees. Everyone in the company needs to be made aware of how data security affects them in their specific roles. And then you have to look at when you send information outside of the borders of the Republic. That's really, really important. And to make sure that where that data goes is a safe place and is an allowed place. Right, data subject access requests. These are the 8 sort of rights that data subjects have. They should be able to contact your business and ask for any one of these 8 requests, right? So, do you have my personal information, yes or no? If you have it, I'm allowed to ask for a copy of all of the information that you have. And again, just looking back at the data map exercise, if you do not conclude that exercise, how would you possibly know where to go and look to find copies of everything you have on someone if you have no idea where you store information, what different applications you have in your environment, what data each type of application is processing, where it's storing it? So you can't actually fulfill the second request or comply with it if you have not completed that data mapping exercise. And then obviously subsequently at Domino's, you should be able to correct information. I know credit bureaus often, if you look at different credit bureaus, they have different addresses for you. That is an example of where you should be able to correct that information easily, and a lot easier than it's happening at the moment. You need to be able to request deleting information, but data subjects also need to understand that it is not always possible for information to be deleted. There are other acts, other laws in place that supersede POPIA in this way. There are financial laws that require for information to be kept for a set amount of time. POPIA cannot override that law. There are, especially with medical records, there are some very stringent requirements in place around the retention of records, and for, in certain cases with certain types of mental health issues, records have to be kept for the duration of that person's life. So there are instances where the information cannot be deleted. Then someone can object to the processing of the information. They can opt in or opt out of marketing, and they should be able to appeal any decision that you've made on any of the prior steps. You have to be able to provide an audit report to the information regulator at the end of the year. So you need to be managing these requests in a format where you will be able to give that report that will show who you helped, how you helped them, how long it took, what you helped them with, what you eventually gave them. You have to verify email addresses and phone numbers before actioning these requests. If you don't do that, you might be giving data to someone who's been social engineering or someone who's phishing. When sending information, you have to encrypt it or redact it as a first option. Think of the way banks send you information. We recommend sending an acknowledgement of receipt of a data subject access request or a DSAR within 10 days. You have to manage that request within 30 days, and you're allowed to extend it one time only, and you must present extenuating circumstances. Where you are unable to verify data subject, you are allowed to reject that DSAR out of hand. But again, should be able to keep a record to show. About security controls. Okay. This is actually quite extensive. Let's see if we can whittle it down. The data audit we've just spoken about. That's creating the map, right? The data map. Implementing reasonable data security protections. That is both with access controls, as you see in the next point, as well as with governance. Ensure access controls are configured correctly, and you need to review access controls on a continuous basis. You need to constantly make sure that people who have access to data this month still need access to the data next month. Has a contractor moved on from a engagement, you need to revoke their access, that type of thing. Ensure activity logs are created, maintained, and monitored. Of course, this works best if you use a document management solution such as SharePoint, where you've got audit records, but there are other solutions out as well. You have to ensure regular scanning takes place, conducting privacy impact assessments, as we discussed earlier. It's not just a one-off, it has to continuously occur. Develop data breach notification policies and procedures. It's not about if you get hacked, it's about when you get hacked. You need to know what to do, you need to know how to inform the regulator, you need to know what to say to data subjects. These things need to be sorted out before this event obviously occurs. So it's really important to get that governance in place. And as we noted before, you have to train all the employees on their responsibilities and provide security awareness training. And you have to regularly review policies, procedures, and safeguards. So that's just good governance, guys. Quarterly, go through your policies and procedures. Are they still applicable? Has the way you do business changed? Has the way your vendors consume data from you changed? In any such cases, you have to amend your policies. So the direct marketing do's and don'ts. Under POPIA, data subjects have certain rights with respect to unsolicited electronic communications. In effect, direct marketing by means of automated calling, which I got just a few minutes earlier. Direct marketing by means of fax machines, SMSs, or emails. The processing of a data subject's personal information for the purpose of direct marketing is prohibited unless the data subject has given his or her consent or the email recipient is an existing customer of the responsible party. The responsible party must have obtained the details of the data subject through sales of a product or service, and the marketing should relate to similar products or services of the responsible party. So if you sold mustard, you can market condiments, but not hardware. The data subject must be given a reasonable opportunity to object to the use of his or her personal information for marketing each time the responsible party communicates with the data subject. So the unsubscribe button must always be there in all of your communications. Then a quick look at differences between POPIA and GDPR. In terms of terminology, these things are the same, just called different things. We have an information officer, they have a data protection officer. Our businesses are called responsible parties, those are called controllers. We've got operators, they call them processors. Data subjects are synonymous, except we include businesses. We give businesses the same rights as people. The GDPR only applies to people. We classify children as individuals of 18 years old. And under the GDPR at 16 and in certain cases 13 years. And then we very specifically look at account numbers. We have a very strong focus on financial account numbers, and GDPR specifically speaks to genetic data. So I'm not going to jump into too much more of the differences between the two. I think the main issue is, or the main difference is that when a breach occurs, POPIA says that the reporting of the breach must happen as soon as reasonably possible, where GDPR is a much stricter timeline of 72 hours. And people often say, if you're GDPR compliant, are you POPIA compliant? Well, not necessarily, but it certainly is not going to harm you if you pick up some of those GDPR provisions, right? Then data movement, transport, information flows. Section 72 of POPIA states that a reasonable party in South Africa may not transfer personal information about the data subject to a third party in a foreign country unless the third party who is the recipient of the information is subject to a law, binding corporate rules, or a binding agreement which renders an adequate level of protection. So in GDPR, the union makes what they call adequacy decisions or an adequacy judgment, where they would deem a certain jurisdiction to have an adequate data protection law in place. The information regulator in South Africa hasn't made any such adequacy findings yet. It's called an adequacy finding. They haven't made any of those findings yet, but often refer to GDPR and it being okay for us to use. Between the states, United States and the EU, they've got something called the Shield Law. That Shield Law has been challenged successfully in Ireland before. And also you have to take into consider that the United States doesn't have a sort of a global, or not a global, but a national data protection law. The different states all have their own laws. So if you've got a processor sitting in one of those or an operator sitting in one of those jurisdictions, you have to make sure that the data law in that area is equivalent or provides protections equivalent to those that POPIA provide. It's really important. So website updates, privacy policies. There are many privacy policy and cookie generators out there, cookie policy generators, and some of them are really useful. However, most versions generated still require a fair amount of personalization specific to your organization's core information use activities. Both cookie and privacy policies have to be updated to comply with POPIA requirements, and changes must be clearly communicated. So you do get really useful plugins and add-ins and things that can help you with this bit. But the way privacy policies need to look now, they really expand exponentially. You really have to be specific. Privacy policies need to include each identifier captured, where that data is transmitted to, what exactly is done with that data, how long is it kept, when will it be destroyed. So those privacy policies bounce out from a one-pager to a 2-3 pager very easily. And a generator can't automatically capture or know what your business activities are. So even though you can get a fair amount of that generator, there's still quite a bit of work that needs to be done to customize it. So the cost of non-compliance. What is the cost of lies? If the information regulator issues you with an enforcement notice, if you've been in breach, one of the conditions of the notice stipulates the type of personal information that you are no longer permitted to process while under investigation for non-compliance. Doesn't always include it, but can include it. If you've been in breach of data protection requirements when dealing with employee data, this might mean that you can no longer process payroll or recruitment or even disciplinary procedures. If your main business involves processing customer or supplier information every day and you get an enforcement notice suspending the processing of any of those categories, your business would effectively stop operating until the investigation is complete. The damage of a suspension of processing is, of course, exclusive of the financial and criminal penalties that you face, and it's also excluding the damages that data subjects might be granted in a civil procedure. So, and I put the point of how long is a piece of string because, so what if you don't submit your tax return? The consequence is going to be different to different people and different businesses. And I can't tell you if it's going to take SARS a month, a year, or 5 years to get to you, but I suppose eventually they will. So we are told the information regulator is staffed particularly well for enforcement. Obviously, as of tomorrow, we will know how effective that's actually going to be. There are no test cases for us to look at. We have nothing to gauge their efficacy against. But do take into consideration that if you get an enforcement notice and they suspend a certain type of data processing activity, it really could bring you to a halt. So examples of contraventions: obstructing the regulator if they're investigating you, failure to comply with an enforcement notice, so if you keep processing after you're told not to, giving false evidence while under oath, unlawful acts by a business in connection with account numbers, financial account numbers, not, client account numbers, unlawful acts by third parties in connection with account numbers, again, financial. We're not talking about, at your doctor's practice, I'm sure you've got an account number. These are not the account numbers that we're talking about. And what are the penalties? Serious offences are potentially up to 10 million rand or 10 years imprisonment. And examples of serious offences are selling account numbers, again, financial, knowingly or recklessly obtain or disclose an account number. And then minor offences, potentially up to 1 million rand or a maximum of 12 months imprisonment. Failing to get prior authorisation for processing that special personal information that you spoke of. So credit checks, background checks, children's data. Failing to give evidence when summoned to do so by the regulator, and obstructing a person executing a warrant. That's when the information regulator comes in to seize endpoint devices, cell phones, laptops, PCs that might contain personal information when there's been some form of non-compliance. And that is it for me, guys. I've decided to skip over a few sections that were a lot more content heavy. I feel like we really did jump into quite a lot. Like I said at the start, it's like a 95-pager, the Act. It's not written so that it's easy for the layman to interpret, unfortunately. But I hope that what I've presented here now helps you guys. And we are more than willing to record your questions in the Q&A and then to get back to you all individually with considered answers, because the POPIA spans such an absolutely wide array of verticals and use cases. It's very difficult to be able to answer all of those, off the cuff, because some of it requires a lot of research, but we are more than happy to get back to you guys with considered answers. That's all from me, Johan, Angus. You guys want to take over?
Thanks very much, Simone. That was a lot of information, and even though I am our information officer, I'm still overwhelmed by all of the various bits and pieces that that I have to comply with. I think there was one question. I don't know if you want to take a look and see if that is something you're willing to take a stab at.
Quickly have a look.
Dropping an answer on that.
I'm just waiting to see.
The question was photos and
groups.
videos and WhatsApp groups.
Okay, so I'm not seeing that one yet. I'm only seeing the WhatsApp group. Yeah, guys, if you join someone to a group, they can immediately leave. So while it's a very practical question to ask, its enforcement or getting around it is very easy. If you don't want to be joined to a group, then don't join the group. I cannot see this really being an issue on a greater scale. It's not like Discovery adds everyone to a direct marketing WhatsApp group. Schools typically do it, add parents to groups and things like that. Families create groups and add you to that. If you could perhaps give me a more specific use case, then I can be more specific with my answer.
Maybe so we community groups, etc. But now I guess where the risk is that I have access to all the contact information or to some contact information for the people in that group. So as a member of that group, I could abuse that data.
Yeah, you could. Yeah. There's no way for us to move around that. There's no way for you to obscure your data or to redact the data that's in there. So if you're on that group, you can see that information. The information regulator is coincidentally engaging with Facebook at the moment because of WhatsApp. So there will be guidance notes issued on the use of WhatsApp in the coming months. There are some provisions in the new privacy policies from Facebook that they disagree with. So I'm not sure how that's going to play out yet. But typically you should have someone's consent before you add them to a group, right? So don't just add people. It's all about consent, explicit consent, not implied consent. No pre-checked, I agree to terms and conditions boxes, no pre-checked, I agree to direct marketing boxes, no pre-checked boxes anymore.
One alternative option is to expose a join link to people that you want to join your group, yes, instead of adding them, give them the choice to join.
Absolutely. I think we've got that at Azuro. We've got that join link. So if you want to join the group, then you follow the link. If you don't want to, no one adds you to the group.
You miss out on all the jokes, though.
Yeah, you miss out on all the memes. So, and we nerd really hard. So. I'm not seeing the photo question.
It was in the name. Let me just drop. There's two comments that came through specifically around. I'm not sure who posted that. WhatsApp groups must be POPIA compliant from the 1st of July.
There you go. If that's what the note says, then that is what it says. From AlphaTech, how does one know if they should be POPIA compliant? So we covered that, I think, in the first and second slides. You will get a copy of this slide deck after the fact or after the session. And I think that will answer your question then. If it doesn't, again, you guys are more than welcome to reach out to us. I think Angus is going to explain a bit more about our involvement after the webinar.
Yes, I was wondering why I was on screen there.
I thought I'll put you in the spotlight for a bit.
I'm too shy for that. Hi everyone, thanks for attending our webinar. I mean, I've been involved with this for quite a while, and I'm still flabbergasted by the amount of information that's come through. And Simone has done a fantastic job summarizing this into something that's practical and workable. From an Azuro point of view, as Jan mentioned, I head up the coastal area, and we've been doing quite a lot of work with some of our clients in this space. And as part of this webinar, we will be obviously sharing this slide deck with you guys. That will be via email. We'll do it today so that we don't have to send you a form to give us consent to do that, and we'll get that out of the way quite quickly. We will also be offering organizationally a free consulting time slot, so that we can answer more industry specific questions, or if you want to take this back to your management team and have an internal discussion, we can line up a call with you guys to go through what comes out of that. It is a lot of work, and there are some very cool tools available. So for instance, if you're on Office 365, there's a compliance manager within the Microsoft toolset that is available depending on the plans you're on, and we can also advise you in that regard. So there's many ways that you can skin this cat, and we're here to assist you if you need that, and also to point you in the right direction for your internal processes. Part of that output will also be some offerings of an extension of the free consulting time slot in order to help you get a plan in place if you don't have one yet, or to just review the plan that you currently have if there are any questions. And we'll get that out to you this afternoon. And just thank you very much for joining us.
Simone, maybe we can just tackle one or two more of the last questions. I think just with regards to Alphatech's question, the detail of it will be in the deck, but as far as I understand it, if you are a business in South Africa, or if you are processing data of a South African person or business or other legal entity, so a legal entity could also be a trust, could be a body corporate, then you are very likely going to have to be POPIA compliant, because you are going to be touching South African data subjects, and as such have to comply with the Act.
Well, it's processing data within the Republic, and it's if you're domiciled in the Republic.
Okay, so
those are the two main.
So it's not necessarily that I've got a South African citizen whose data I'm collecting, but I'm not collecting that data in South Africa.
No, not necessarily that.
Okay. No, that makes sense.
And then I see a question: is there a grace period? So the grace period expires at midnight.
Yes. Yeah, that's the sad truth. There was a note published about a extension to February next year, but maybe just clarify what that was in relation to.
Yeah, so that extension is only about applying for prior authorization for permission to continue processing certain types of special personal information for the credit checks and the background checks and the criminal checks and so on, and then continuing to process children's information. It's about requesting consent to continue that processing. That process has been, or that application run cycle has been delayed or postponed until the end of February, I think, next year. But it has absolutely no bearing whatsoever on the POPIA go live tomorrow morning or midnight. Our Y2K is tonight.
And then I think the last one is consent for photos or videos that's used on a website that's old, in other words, prior to the enactment of the Act.
Well, photos and videos usually are accompanied with a release form. So that should cover your photos and videos. If you don't have those releases in place, you should go and get those releases in place. People have to consent to their information being used, and the information can include images.
Great. I think if there are no further questions, then we give you back about a minute and a half in your day. I'd like to thank everybody. Really thank everyone for joining us this morning. Like I said, it is our first webinar, and hopefully not our last one. We will endeavor to do some more on varying topics in our purview. But please do let us know what you thought of the content in the webinar, as well as if there's any other information or content that we could produce for future webinars.
Excellent. Thanks, everyone. I appreciate your time.
Thank you very much.